Years ago
Yes.
already, now 2013, when Begaiym was still working on the PhD on the issue she will be discussing today. Now she has defended the PhD, she has been on a fellowship at Indiana University, so we are taking advantage of her being in the US to stop by and presenting the new research. Otherwise, Begaiym is an associate professor of law at the American University of Central Asia in Bishkek, and she has been really working on this absolutely critical issue for the whole region, but particularly for Kyrgyzstan, which is to look at foreign investment law and the relationship to sustainable development in the mining sector. So really something which is absolutely vital for the Kyrgyz economy, and it's really great to have someone like Begaiym who has been looking at that, because usually it's a very policy topic, so you have people on one side or on the other with very kind of biased or advocacy position, and it's really important also for scholars and for having a kind of more neutral academic perspective looking at these issues on foreign investment law in the mining sector. So Begaiym, I give you the floor, and then after we will open for discussion.
Thank you very much, Marlene. It's a great pleasure and honor for me to be here. Thank you all for coming. I would like to give a presentation, and then if you have questions, please free to interrupt me and ask questions, or we can also have all the questions at the end, whichever you would prefer. The topic of my presentation is foreign investment law and sustainable development in the Kyrgyz Republic. I would like to speak first about the context and significance of this subject area, and I would like to discuss why it's so important for the Kyrgyz Republic, and then speak about Kyrgyzstan's investment law, and finish up with some of the legal reforms and recommendations. So first things first, context and significance. When it comes to the topic of foreign direct investment, a lot of countries obviously compete for FDI because FDI brings a lot of, a lot of benefits. It's generally considered to be the driving force of the economic development. It, of course, provides great contribution to the increased capital flows into countries with limited domestic financial sources. It does provide for technology and management skill transfer. So a lot of countries in the world, both developed and developing, have been enacting various kinds of measures in order to attract as much FDI as possible. However, at the same time, it's also important to note that there can be some negative aspects associated with FDI, not just the positive ones. And what has happened is that the international competition for investment has led to the race to the bottom in terms of the regulatory framework. Number of countries willing to attract FDI have lowered down their regulations, for instance, environmental regulations, in order for more investments to come into their countries. And then FDI in a number of countries has contributed to various environmental, public health problems, right? It has led to social disruptions. I would like to start my presentation with just one concrete example of what happens in a country that has received the FDI and how it basically faced those negative aspects, and that's Nigeria. You see pictures of oil contamination in the Ogoni region of Nigeria. That's where Shell company operated. As you can see, there was a lot of environmental pollution, and even up to these days, we see a lot of environmental pollution there, oil spills, fires, and the most striking image of all for me is this picture of a local village. That's where a lot of fishermen used to fish, used to have their whole livelihoods depend on resources of the local area. Now, as you can see, if you look closely, you see oil spills everywhere, and these people have to drink water, with oil inside, and then they've had many problems with fishing and other issues. According to UNEP, contamination of soil, groundwater, degradation of vegetation, major health risks All of these problems occurred due to spills and flares. And according to the estimates, it will take up to 25-30 years for restoration of the area, and a restoration fund of at least $1 billion is needed to clean up this area. And the reason why I started my presentation with this particular story is I think it is telling. When it comes to FDI, it's really important to see not just the positive aspects, but also be aware of the negative aspects and perhaps be proactive in terms of mitigating any possible negative aspects. And so the key question is, what can we do in Kyrgyzstan in order to make sure that we don't have our environment polluted, that we don't have any major public health related issues, that we don't get the social disruptions due to FDI that we are receiving. The country, just for those who might have not been to Kyrgyzstan or have read much about Kyrgyzstan, Kyrgyzstan is a country in the heart of Central Asia. It's landlocked. 94% of the country is 1,000 meters above sea level, and it's definitely a beautiful state. If you look at some of the pictures, we have the natural beauty as evident from those pictures, and have wonderful landscapes. But one of the major issues is that the ecosystem of Kyrgyzstan is very fragile, unlike in areas where the areas like the territory is completely flat, let's say. Whatever happens in this mountain ecosystem will have greater impact on the environment. And we do have, right now, as you can see, the highest peak of Kyrgyzstan is 7,439 meters. And we have mining so far at 4,000 meters. And you have zones of active glaciers in most of the territory of the Kyrgyz Republic. Mining brings, mining companies contribute most to our economy, and a lot of those mining sites are located in the zone of active glaciers, which means that there has to be extra care when it comes to issuing out permits and negotiating perhaps investment contracts with investors that would like to conduct their operations in such areas. Now, in this case, when it comes to going back to the question of what we can do to make sure that investment brings sustainable development to the country, the major question is, how do we make sure that foreign direct investment is in line with sustainable development objectives? And right now, sustainable development goals have been adopted by most countries around the world. Sustainable development in general is understood to be development that meets the needs of the present without compromising the ability of future generations to meet their own needs. When it comes to the investment legal framework, here, of course, historically, most of the laws and contracts as well as investment treaties, not just in Kyrgyzstan, but all around the world, have been focused more on protection of investors. That was the initial purpose. That's why we have the entire investment regime. The legal framework basically has offered a lot of protection to investors. I will talk about what types of protection a little bit later, but in general, no notions of sustainable development have been incorporated into investment treaties and investment contracts. A lot of the times, investor rights are specifically and clearly stated, but then post-state the investor obligations are not there. And the question is, of course, can we continue with this asymmetrical regime, or should we do something about it? And currently, the emerging investment paradigm is that it's no longer enough to have a framework where the investor deals with the state, like face to face. It's important that here we have also society, like communities, which may be potentially affected by investment, also come into play, and then also engage in this relationship. And it's also important to consider the environment, the protection of the environment, as we are trying to attract and have FDI in our states. The evolution of investment promotion and evolution of investment regulation are particularly telling in this regard. So if you look at investment promotion, the first generation focused on the liberalization of FDI regimes. The idea was to adopt market-friendly policies to make sure that investors are coming into the country, so there maybe certain regulations would be relaxed, or there will be some concrete measures undertaken in order to attract more FDI. And then you had investment promotion agencies set up, and just for that purpose, you also had the third generation with matching of industries with specific countries. But then finally we are now moving into the fourth generation, where the focus is on attracting not just any kind of FDI, but FDI which will result in sustainable development for the host state. And similarly, the evolution of investment regulation is also interesting. In the beginning, the idea was to focus on political goals. The idea was to protect investors from outright nationalization, like taking of property. A lot of investors would not go to certain areas around the world for fear of having a direct expropriation and for fear of not having access to courts that would be fair to them. So the first generation really focused on opening up certain areas around the world to greater FDI by providing investors with protection there. And one of those types of protections is the ability to initiate an arbitral claim and to start an arbitration proceeding against the host state, where an individual investor can file an arbitration claim based on the breach of, let's say, a bilateral investment treaty or an investment contract that the investor concluded. The second generation focused on economic goals. Again, the idea was you need FDI in order to have economic development. So at this point, the idea was open up, make sure that there's liberalization of the market. But now again, the third generation started focusing on social goals. Again, the idea is to make sure that it's not just any kind of FDI, but sustainable FDI that comes into the country. And you can see this trend in different kinds of reports and in the work of various important institutes around the world. One example is UNCTAD. Their very influential World Investment Report in 2012, for instance, focuses exactly on this new generation of investment policy for sustainable development. And then, you look at other reports that talk about investing in the SDGs, Sustainable Development Goals, and that connect sustainable development with foreign direct investment. When it comes to scholarly work, expert works, expert opinions, you see that the growing number of experts are also calling for the greater connection between FDI and sustainable development. For instance, Brundtland said that sustainable development cannot be achieved without socially responsible investment, that the two go hand in hand together. Sir Lauterbach also said that sustainable development law and policy can and should be developed and implemented within investment regimes. Again, calling for a greater alignment between sustainable development goals and investment regulation. Now, that was the context and significance of the research. Now, the part two focuses on Kyrgyzstan's investment law and some of the major sustainable development related problems that one can observe right now. When it comes to the legal framework, Kyrgyzstan has international investment treaties. We have ratified a number of treaties, more than 30 treaties with various countries all around the world. We have an investment contract. We have national legislation in the form of a law on investments. And we also have impact and benefit agreements. These are agreements that have been signed between local communities and investors, where investors would agree to provide certain benefits to local communities. And then local communities would then somehow help investors in their projects. So at this point, if you look at this legal framework, the most problematic right now is the first one, the international investment treaties. And therefore, since I don't have much time, I would like to focus on international investment treaties of the Kyrgyz Republic and talk about some of the major challenges that we're having with those treaties. First of all, I'd just like to define what this treaty is. At the international level, there is no single treaty like in WTO area. We don't have a single multilateral investment treaty. So what we have instead is, again, treaties that are signed either by different countries individually with one another or a lot of regional treaties. So far we have over 3,000 bilateral investment treaties worldwide. This treaty is essentially a treaty between a host state and a home state of the investor. And the treaties guarantee protection of investment, and then they provide for a certain number of rights and guarantees. And typically this treaties also give investors the opportunity or the right to initiate an arbitration claim against the host state in case the host state has breached a certain duty under the bilateral investment treaty. Right now, we have more than 30 bilateral investment treaties, and most of them, unfortunately, are old generation. And by old generation, I mean they provide a lot of protections to investors. They focus on investor rights, but not on investor responsibilities. And then they provide for a number of different types of standards and guarantees. I'd just like to read some of them. This is a guarantee of fair and equitable treatment, expropriation, protection from expropriation, both direct and indirect, full protection and security, most favored nation treatment, and other rights. Now, at first sight, this might seem to be standards which would be good to include in any kind of treaty and to protect investors. But unfortunately, in a number of cases, the interpretation of arbitral tribunals of these standards has not been what states expected. A lot of the times, what happened was that a certain investment protection treaty was interpreted in a way which was not anticipated by a host state. So for example, I'll just give you one example. This is a standard of fair and equitable treatment. It's very vague, right? I mean, what is fair? What is equitable? What is fair to you might not be fair to me. So at this point, there's a lot of debate on the meaning, on the exact meaning of the standards. So one of the standards is FET, and according to one of the treaties of the Kyrgyz Republic, Kyrgyzstan promises that investments made by investors of each contracting party shall at all times be accorded fair and equitable treatment in the territory of the other contracting party. So it's just one sentence. There is no explanation whatsoever what that means, and all that is left to investment arbitration tribunal to decide. And in one case, it's not related to Kyrgyzstan, but it was interesting for me to see how the tribunal interpreted that standard. in TechMed versus Mexico case, an arbitration tribunal basically stated that FET means the following, that, in this case, the state has to act in a consistent manner, free from ambiguity and totally transparently in its relations with investors, so that it may know beforehand any and all rules and regulations that will govern its investment, as well as goals of relevant policies and administrative practices or directives, to be able to plan its investment and comply with such regulations. Again, this is just, of course, there are different tribunals, and other tribunals, depending on the wording of the standard in other treaties, has interpreted this differently. But this actually shows that the meaning of FET can include, violation of, let's say, of being not totally transparently. And the question is, which country in the world can be acting totally transparently, or like acting in a consistent manner, free from ambiguity? Of course, it's clear that the standards are there to protect investors, and there have been a number of times where, of course, this was very necessary, but at the same time, what we see right now is the emergence of arbitral tribunal practice where, certain standards are interpreted in a way, in a very expansive manner. And a lot of states are now thinking that, to avoid this, they need to either terminate their treaties, or so that they wouldn't end up having an arbitral tribunal interpret this, treaties in such an expansive way, or somehow reform them. And some states around the world have decided to terminate their treaties. One example is South Africa. After having a case against South Africa, they decided that they do not want an arbitration tribunal limiting their power to regulate, because if you see, like, when it comes to those standards, there are such standards as regulatory expropriation. And regulatory expropriation means the following: a country can pass a law, let's say, on protection of certain areas where environmental harm should not be done, and then if that affects a particular investor, the investor can then bring an arbitration claim against the host state, stating that this affected them, and that state now should compensate for that negative effect of the regulation on investors' business. So therefore, the big question now is, can states really regulate now? Because anytime they pass legislation, perhaps it might impact an investor. It happened in the case of Australia, for instance, that Australia wanted to regulate its, the tobacco packaging, and then Philip Morris filed a claim against Australia, stating that new regulation on their tobacco packaging actually affected them negatively, and so they brought an arbitration claim against Australia. And so again, questions like that, I think, permeate the entire legal framework of FDI, and this is especially evident in case of vague standards such as regulatory expropriation or fair and equitable treatment. The other one is full protection and security. Some have interpreted this standard to mean full legal protection and full legal security, meaning, again, that it's a very high standard, and a number of states have not been very happy as to how the standards have been interpreted. So far, Kyrgyzstan has faced more than 13 investment arbitration claims from investors, with a total of more than $1 billion in claims, and this have been actually, mostly in the mining sector. As you can see, one is like a $500 million case, others like $600 million, $117 million, These cases are all, like, most of them are available, so it's possible to actually read the award. But unfortunately, some of them are confidential, and we don't know what the decision was, and we cannot read why, let's say, Kyrgyzstan lost, like why Kyrgyzstan has to pay this amount of money, because this is not possible to access. And so this is the major problem when it comes to investment treaties, and of course, the idea is that if we terminate those treaties like South Africa, that could probably impact the investment climate of Kyrgyzstan. We don't want to have that happening. We do want investment, and we do want to make sure that we have enough investment to have economic development. But at the same time, if we continue signing treaties of the nature that we have signed so far, and if we continue having the same old generation model BIT, then unfortunately we are also going to face the risk of arbitration claims. So we might have, I don't know, like an investment in the amount of 500 million, but then we'll have to pay the same amount to the investor in case we breach some of those vague investment protection standards. So if you look at it, it's very important to understand that bids bite, that bids actually can hurt, and the interpretation of those investment protection standards is very contentious. And one investment arbitration expert noted actually that if the states are to be protected in this regime, it's important for them to explain what they meant by fair and equitable treatment, or what they meant when they said that they will accord, let's say, protection against regulatory expropriation. What kind of regulations are they protecting from, right? Is it just any kind of regulation, or maybe a regulation which was discriminatory? So at this point, I think a lot of questions remain when it comes to this investment regime, and I will return to this later. So, and part 3 is about legal reforms and recommendations. The proposal is to make sure that Kyrgyzstan can maximize the positive contribution that investors can bring to Kyrgyzstan, and to avoid any kind of negative impacts. I mean, that's the idea. And another objective is to ensure that investors comply with the local legislation, and finally that investors are not just coming and complying with the law as it is, but are also doing something to comply with some of the voluntary standards, like some of the best practices around the world, where they could comply with certain human rights standards, and even if those are voluntary. Yeah. When it comes to bilateral investment treaties, a lot of the times, well, a treaty would consist of a preamble, the main part, and then the last part where it talks about where it was signed. So I feel that it's very important to talk about sustainable development in the preamble, in the part where the objectives of the treaty are stated. A lot of the treaties of the Kyrgyz Republic state that the major objective of the treaty is economic development and protection of investors. And so when, let's say, an investment arbitration tribunal looks at that treaty, they read the standard in light of the preamble, in light of the objectives of the treaty. And when the objective is economic development, right, protection of investors, but when nothing is mentioned about sustainable development, then of course that gives room for investment arbitration tribunals to interpret the standards more in favor of investors. And so one recommendation is to have references to sustainable development in the preamble, in the substantive contents of the agreement, It's also important, I think, to include some general exceptions to the standards. For instance, there could be a standard protecting against indirect expropriation, but at the same time, there could be an exception made there. That, for instance, in the case that a host state adopts a certain regulatory measure, which is done in good faith without any discrimination, then the host state does not have to pay if that regulation somehow negatively impacts the investment and the investors. It's also important to clarify the scope and meaning of specific obligations, and I have some examples that I think are very important from all over the world. Some countries right now are trying to basically spell out the meaning of the investment protection standards. So what does fair and equitable treatment mean? And then they have a list that fair and equitable treatment means the following. And then like no denial of justice, and then a number of other provisions are provided. So in that case, that allows host states like the Kyrgyz Republic and other states to provide greater clarity to the scope and meaning of the standards, and to allow for again greater control of the treaties they sign. There could also be explicit reaffirmation of parties' commitments under international agreements they've concluded, like international agreements on labor, human rights, or environment. And then inclusion of some of the not lowering of standards clauses, where they affirm that they're not going to lower any of the environmental standards or labor standards in order to accommodate like more FDI in the country. Finally, there could be some corporate social responsibility clauses inside those treaties. So right now, these treaties are, they don't mention, most of them don't mention this. They just have 3 or 4 pages. They speak, they provide all those guarantees to investors, but they do not place any obligations on investors, and they're not specific enough as to help the country, let's say, during the investment arbitration proceeding, to explain what they meant when they signed those treaties. Just to provide you with some examples, again, this is all emerging. And I think countries around the world, not just Kyrgyzstan, but countries all over the world are trying to find the formula, like what wording should they use in order to guard them, to protect themselves against possible abuses by investors. And in one FTA, for instance, Canada-Peru, the parties affirm that it's inappropriate to encourage investment by relaxing domestic health, safety, or environmental measures, and that a party should not waive or otherwise derogate from such measures as an encouragement for the establishment, acquisition, expansion, or retention in its territory of an investment of an investor. So again, that's a very explicit affirmation of the importance of environmental standards, and other like social standards, as opposed to just focusing purely on protection of investment, to the detriment of other goals. And then the same is provided in the United States Model BIT of 2012. You see here that the idea is that the parties should not derogate from the environmental laws in a manner that weaken them. Again, the same basic idea that it's important to uphold those regulations and make sure that they are complied with. I also like this example of Finland and Namibia BIT, where in the very preamble they speak about how the objectives of the treaty can be achieved without relaxing health, safety, and environmental measures of general application. So this is what I was talking about when I said perhaps there could be some references to sustainable development in the agreement preamble. so that when investment tribunals will be looking at the agreement, they will be guided by this objective here. There could also be clauses on compliance with domestic legislation, which is also very important, and then some clauses on corporate social responsibility. And some of the examples are, some of the model bids or some of the investment agreements that can be found that, the investors should comply with all the domestic legislation, that the domestic legislation should apply to investors. In some cases, around the world, there have been cases where, let's say, the domestic legislation was frozen in time. So what can happen is that an investor can come to a country and then negotiate an investment agreement where they could say all the environmental laws and regulations as of will apply, but if you basically change them after 2018, those changes are not going to be applicable to our investment project. This is called a stabilization guarantee. And so the idea with this types of clauses is to make sure that investors still have to comply with domestic legislation and make sure that you don't limit the possibility of host state to enact measures of this kind. And then corporate social responsibility, this is about encouraging investors to comply with widely accepted international standards, such as the United Nations Guiding Principles on Business and Human Rights. And this could be done by providing a list, a certain list, giving a general references, or spelling out the content of relevant standards. That's where there would be a list of what the states meant by agreeing to provide fair and equitable treatment, for instance. In this BIT, you have a very interesting reference to just international recognized standards of corporate social responsibility. This is in itself very vague, I guess, but right now you see all different types of measures undertaken by states in order to make sure that there is greater alignment between sustainable development and foreign direct investment. And I think when it comes to the Kyrgyz Republic, it's very important that we start reforming our investment treaties, and that the next treaties to come, that they are in line with sustainable development. Otherwise, if we continue being on the same path of having those very vague standards in our investment treaties, then we might have problem in terms of having more investors just use those treaties as a way of claiming compensation against Kyrgyzstan, even in cases where such claim might be frivolous in the first place. And then finally, I just wanted to end my presentation with two more examples. Some institutes around the world, even though they're not, they do not represent country, but they're independent institutes. They also come up with their own model BITs that countries like Kyrgyzstan could look at. There are a lot of different models available right now. And so some of those models, for instance, refer to the major instruments, and they provide guidance as to how certain standards should be interpreted. And then this final example is the new Brazil-Malawi CPIA, where they talk about the importance of achieving the highest possible level of contribution to the sustainable development of the host party. There is an explicit affirmation of the importance of sustainable development, and then they basically list all the different goals and the importance of environmental protection, social protection, and encouragement of measures contributing to sustainable development. So this is, in general, what I wanted to focus on as part of my presentation. There are many issues that we can speak about more, of course, if we had more time. Overall, at this point, I think Kyrgyzstan is ready to start the reform. Kyrgyzstan will be reforming its model bilateral investment treaty, and we will be, of course, signing and ratifying new agreements. And so the hope is that, you know, as we do this, that we get it right, so that we don't have a situation where we attract FDI, but then that FDI does not necessarily contribute to our sustainable development. Kyrgyzstan is about the size of the state of Kansas, so it's small, right? And we have all those natural beauties we want to protect, while we do want to also develop economically. So I think it's very important to make sure that there is a right balance between the protection of investors' rights, which is extremely important. Okay, I think you know, we should continue protecting them, but at the same time, we must make sure that that protection does not come at the expense of weakening of environmental regulations, that it doesn't come at the expense of, you know, maybe like limiting liability of investors, and you know, which path should we choose? Well, that depends, of course, on the policymakers. Right now, we've had, there is the Columbia Center on Sustainable Investments of Columbia Law School and Columbia Earth Institute. They came to conduct trainings for the governments of the Kyrgyz Republic on how, you know, the government could actually reform the treaties. We also have UNCTAD helping us in terms of our reform efforts, but I think more is needed, like more trainings and perhaps capacity building is needed for Kyrgyzstani officials to you know, enact the right types of reforms. And hopefully all of this will contribute to the sustainable development of the country, where the government, the investors, and the local communities will be able to work together towards the achievement of sustainable development goals of the Kyrgyz Republic. Right, so that was it. Thank you.
Thank you so much, Begaiym. That was really very interesting, and I really thank you for having made that kind of clear and understandable for those who are not specialists on all these legal issues, which is the case for the majority of us. I have several questions, but maybe I will open the floor for questions, and then, yeah, I was sure there would be. Let's begin. Sebastian, you have the floor, and then.
Sébastien, vous avez research for research here, the Central for sent to you